You'll see from the slides that should also come up beside me that from the point of view of the exam, the constitutional law examiner is very, very clear about what he wants from students, and there is, I suppose, no room to not provide him with what he wants. If you don't give him back what he wants, you won't pass the paper, and he is a tough marker, and you should be aware of that from the outset. There is no taking, I suppose, shortcuts in this syllabus. So you'll see that what he has said he wants from students is he wants students to understand the concepts that underpin constitutional decisions. So ideas like, which we will see, presumptions of constitutionality, mootness, locus standi, proportionality, non-justiciability, all of these ideas underpin every decision that a judge will make where there's a question over the constitutionality of a piece of legislation or some restriction put in place by the state that limits an individual's constitutional rights. He obviously has said time and time again on the paper that he wants students to have a contemporary understanding of the law and society. So where there is a recent referendum, students should be aware that maybe it hasn't drastically changed the position, but to the extent that it has changed the position, there will probably be a question on the paper that will require a discussion. Whether it's clear or not on its face will just require a discussion of the topic of the referendum. He wants students to be very aware of recent decisions, as we said, in constitutional amendments. So the legal decisions that flow from constitutional amendments and or the legal decisions that give rise to the necessity to amend the Constitution or strike down legislation and amend legislation. He wants students to ask or to answer the questions which he's asked, not the questions that students want to come up on the paper. And again, that goes for every exam that you will sit at FE1 level. You answer the question which is asked. You deal with every line of every sentence, every word in every sentence, and you answer it in that way and frame your answer and your the cases that you choose to that extent. Finally, obviously, and I say this to my students time and time again, he expects a holistic approach to the manual, okay? And I use the manual, obviously, as an example, to the constitutional law syllabus generally. And what I mean by that is, you cannot, with this subject as opposed to other subjects, you cannot learn the chapters in isolation of one another, because every chapter leads on to the next chapter, and every chapter provides the building blocks for understanding the following chapters. In that regard, unfortunately, it's very hard to limit the constitutional syllabus, and whilst I would point out to you areas that he tends to like or that have come up recently or that are topical, it doesn't mean that the other chapters can be left out at all. Apologies. Moving on to the next slide. So that's what does he want from me? What's hot and what's not? And this is the easiest way, I suppose, to deal with the topical issues at the moment. The examiner in recent times, as I've said, has shown a tendency to put questions on the paper concerning contemporary issues. So, for example, on the recent papers, you would have had questions in relation to Article 42A and the amendment to the Constitution and what that meant for the rights of the child. You would also have had questions that focused around decisions like McChrystal and Jordan, and when the courts will intervene in the manner in which, if you like, the state hold referenda. Similarly, in much more recent times, as in the last year, you had cases like Bederev that dealt with the separation of powers doctrine and saw a rowing back from previous decisions like John Grace Fried's Chicken and McGowan, where the court were happy to strike down legislation, and in fact eventually being appealed to the Supreme Court saying, no, hang on, take the act as a whole, it does provide sufficient guidance. And look, we do more of this, and this will mean more as you move through the course, but what I want to get across to students is this increasing tendency to put 1, 2, 3 questions on the paper in relation to areas that are particularly topical. Even where they're in a state of flux, they still appear on the paper to some degree. I've also looked at, and I've just mentioned it there too, Article 38.1 being incredibly topical at the moment. And Article 38.1 deals with trial in due course of law, or what we call in America due process. This idea that every person is entitled to a fair trial, and that doesn't just extend to the trial of the action, but everything that precedes the trial of the action. So from arrest to custody to eventually being tried in a court of law. Your due process rights apply equally across the board, and recent decisions like Gormley and White, which deal with the right of access to a solicitor and your right to have a solicitor, or to have access to a solicitor, prior to being questioned, coupled with the obiter comments of Judge Clark in that regard in relation to the right of access to a solicitor during questioning all make this very topical for this exam, and indeed it appeared as part of the case note question on the last paper, and I would anticipate that it would appear in a greater extent on this paper. Similarly, in relation to JC, or the recent decision of JP, which appears to have created a situation whereby the previous position on O'Brien in relation to unconstitutionally obtained evidence and fruit of the poison tree, I suppose the previous test in O'Brien has now again come full circle and appears to be the test that will be applied by the court in light of the decision of JC. There was a rowing back from that to some extent in Kenny, which was hugely criticised by a judge called Judge Charlton, in a decision called Cash. And now there appears to be, I suppose, a renewed vigour to balance the rights of the victim with the rights of the accused again. So hot right now, I've described it as being the separation of powers doctrine. And again, I said to you, there are decisions like John Gray's Fried Chicken, McGowan, and more recently Bederev, which deal with the separation of powers issue. So again, incredibly topical for the exam that students are about to sit, and perhaps going forward again. Findings of unconstitutionality, terminology and effects is a topic that we cover, always important. There was a decision called Damash, which concerned guards basically issuing search warrants in their own investigations, so without the need to have an unbiased independent party issuing the search warrants, they were allowed to issue search warrants in their own investigations, and this was found to be unconstitutional for the very reason that it was biased. And as a result of that, there's been a plethora of cases that flowed from that, where people are appealing their decisions on that basis. So again, incredibly topical at the moment. Religion, always an important issue, important in recent times in light of everything that's going on a national and an international level in relation to terrorism, blasphemy, what happened with Charlie Hebdo. So again, this becomes a very topical issue, also from the point of view of schools and the right of access for children who maybe aren't of Roman Catholic denomination, their right of access to schools notwithstanding their religion. So again, an incredibly important topic. A newcomer to the category, abortion. Obviously you have the recent Protection of Life and Pregnancy Act, and you have the calls at the moment, which you will see all over social media, about repeal the 8th. So for the first time, people are citing, and very young people and very old people are citing from the Constitution. And I suppose it's drawn an increased awareness to that small little blue book that obviously has always been incredibly important in a sovereign and democratic society, but now people who have never studied are citing aspects of the Constitution. That's very exciting for constitutional lawyers and very interesting, because it shows a real contemporary awareness of what it means and what it means for people. Again, an important topic that maybe wasn't so important in the past from the point of view of an exam has become very topical in recent times. The family and education, again, also very important, as I said to you, in light of the calls to remove, I suppose, preferential treatment for children who are of the Catholic religion in relation to admission to schools. Freedom of expression, always a topical issue. Again, you tie it in with Charlie Hebdo, you tie it in with blasphemy in the Constitution, and you say this is something which we can't ignore for the exam. It's always been topical, but incredibly topical in recent times. Your property rights, very, very topical during the recession in relation to compulsory purchase orders. The examiner tended to put them on the paper more, but again, still topical for this paper, always a live issue. Property, land, the field, they're huge issues in Ireland for Irish people. We feel this intense urge to own property, and we feel that any restriction on our property rights is, I suppose, significantly impacts Irish people more than maybe in other countries. From that perspective, it's incredibly topical on the exam and does tend to come up quite a bit. Again, always hot are your fundamental rights generally. So your right to life in your Marie Fleming case in relation to whether or not assisted suicide and the law that governs assisted suicide should be declared unconstitutional, whether or not the right to life includes the right to die. Your right to privacy, obviously also important in relation to surveillance issues, etc. Always important topics. Finally, perhaps the most important things, as we said, proportionality, the double construction and mootness, look standout presumptions, and reach constitutional issues last. All issues that we deal with throughout the course of the manual that underpin every constitutional decision, and coupled with that, obviously, constitutional interpretation, which isn't there. What's not, it's very important that and I'm going to conclude with this, but the idea that what is hot and what is not depends on the state of the state, if you like, at the time of drafting or writing the constitutional paper. So it's important to say that the constitutional paper, like a bold child, is generally a product of its environment, and the examiner tends to take a very contemporary understanding. Like a practical and prudent practitioner, he looks at what is relevant at the time that he drafts the paper, and generally we can say, I suppose, with as much confidence as one can with an exam that they don't set, that he tends to put those type of questions on the paper. Again, there are topics which haven't always found favour with the examiner, but depending on what is topical at present, issues like abortion may well appear more frequently on the